Good afternoon. Well, the Justice Committee of Parliament has now formally decided that the National Assembly must vote to remove both Western Cape Judge President John Hlophe and retired Judge Nkola Motata from office. They will become the first judges in our democratic history to be removed from office in this way. Hlophe has been found by the Judicial Conduct Committee to have tried to influence Constitutional Court judges in cases relating to then future President Jacob Zuma. This all happened back in 2008. Motata was found guilty of wrongdoing relating to the way he drove his car into a wall in Joburg and his conduct afterwards. As I understand the Constitution, 2/3 of the members of the National Assembly would have to vote to remove these two judges. Alison Tiley is the head of Judges Matter. Alison, good afternoon to you. This is quite a big moment in a way. This has never happened before. How significant is this?
Well, it's very significant. I think one of the reasons that it is so significant is that we've often talked about whether and how judges are held accountable. And I think sometimes it seems as though it's so long coming that it may be that they're not going to be held accountable. But this is, I think, the moment where it is sent to Parliament for the vote. And I guess this is where the rubber hits the road in terms of that final decision as to whether or not they should be removed.
Is the National Assembly vote the last move in this, or does the President also have to act?
Yes, the President does also have to act after the adoption of the resolution by Parliament. But that would be a formality. The President wouldn't make a decision that went against that of Parliament.
Okay, so it would be very similar to what we saw with the removal of the former public protector, Busisiwe Mkhwebane. MPs vote, you need 2/3. After that, the President literally receives the recommendation and sends a letter.
That's how we understand the process. But as you say, it's the first time. So, you know, nobody can say for sure, but that's certainly what the Constitution envisages.
There's quite a lot at stake here for the two judges, and Judge Hlophe, as I understand it, says it would be wrong for the National Assembly to vote to remove him now because he still wants to appeal certain parts of the Judicial Service Commission's findings, and there's been appeal after appeal in his case. Is there any reason Parliament cannot go ahead against him at this stage?
No, and I think that the committee has been at pains to look at this question, and effectively what it means is that the Judge President, in the way he is approaching the courts, can't use applications for appeals to stop the process in Parliament. The only way to do that would be directly to approach a court and ask a court to stop the process, which he hasn't done, and which I doubt would succeed. I think his appeals have generally been more about the decisions that have been made about his conduct.
And Judge Motata, he says that he's already had to pay a fine, so if he were now removed, he'll be punished twice. There'll be a double jeopardy. Is there anything in that argument?
Not as far as we understand it. I mean, the question of what happens to the fine is one that we've never had to deal with before, and as I understand it, that will have to go back to the JSC. But this process will continue irrespective of the fine that was previously levied. The JSC, when it made that decision, had said that it was not gross misconduct, and of course that's now something that we've now know is true, that it is gross misconduct according to the Supreme Court appeal decision that was handed down in his matter.
In our system, a judge gets paid a salary. They get paid that same salary after they're retired, so they get paid for life. That's different to most other people, but they do that. It's done that for a specific reason. It's to make sure that they understand that they are sort of set for life in a way, and so there's no temptation. So would both of these judges lose those benefits if Parliament votes in this way?
They would, but I think you have to remember that both of them have been receiving a salary ever since the incidents in 2007 and 2008, and we do pay our judges reasonably well. A judge president at this point receives over 2 million rand in salary a year, and a judge around 1.9 million. So it's a considerable amount of money that has been paid to them, both in the duration, and of course they've had free legal assistance. The taxpayer has paid for their lawyers at each step, although there's been a dispute about how much should be paid. It's a debate that's happening elsewhere. But I think that it's difficult to say at this point that they are being in any way shortchanged or, badly done by, given the amount of money that they have earned in the interim.
Would there be anything to stop them acting as lawyers? I know Judge Hlophe came to the bench, if I recall, through academia, so there might be issues about sort of being registered, but never mind all of that. Would there be any prohibition from them, taking clients as advocates if they so chose?
Well, I think they might have some difficulty because in order to do that, you have to be a fit and proper person. And if you've been removed as a result of gross misconduct, I think it's difficult to see how that would be possible. But they are both towards the ends of their careers. Certainly, Judge Motata, I think, is approaching his 80s. I'm not sure that it's reasonable to anticipate that they would go back to work. It seems unlikely to me.
We've seen so many questions, and you'll know, Alison, that, being a judge is a contested space. It is in many societies, but it is particularly in our society at the moment. And there are questions around how judges should behave, what they should say, what they shouldn't say. If these two judges are removed by the National Assembly, would it send a sort of impact through the rest of the bench? Might it have the impact that other judges realize that actually they do need to behave and that there are particular rules, and we've almost lacked precedent in this, so that just alone could be important?
I think it could be. Certainly we know that our conduct process is improving in terms of the time it's taking to process matters, largely because of these judges. I mean, they've appealed and tested the entire conduct system from bottom to top. So we have a lot of decisions now from the courts on the constitutionality of the process. I think what we're looking for now is trying to deal with matters quickly. It's certainly not fair on judges and also on complainants to have these clouds hanging over judges' heads for years and years. So I think we're really hoping that the Justice Minister takes up the call from the Judicial Service Commission to expand the number of judges who can deal with disciplinary matters, which would presumably then allow them to deal with them more quickly.
Alison Tiley, Head of Judges Matter, thank you very much indeed. Do appreciate the time.